We are competing in the business law competition for PBLState2020. My name is Natasha Haslam, and today with my colleagues Andrea Seager and Landon Haslam, we will be discussing a court case involving a corporate data breach. E-commerce has been transforming trade as we know it since its inception, with both positive and negative consequences resulting. One major change, though, is that data breaches have become more prevalent in recent years, and companies such as Equifax, Google, and Target have all experienced the bad press and the legal consequences that result from a data breach. The particular data breach that we'd like to focus on today is of Zappos in 2012. While this was far from the largest data breach in recent history, it was a groundbreaking case as it resulted in major changes in prioritization and responsibility in data security.
Zappos.com Incorporated is an online shoe retailer which was acquired by Amazon. It primarily distributes other well-known brands, including Vans, Asics, Birkenstocks, and many more. In the court case Zappos.com Incorporated v. Stevens, 24 million people's data was stolen in a data breach. Although there was no evidence of harm to the victims, many were afraid that future harm would come because of this data breach, and asserted that Zappos was responsible for protecting their data and failed to do so. The case was filed in a U.S. District Court in Nevada, appealed and reversed in the 9th Circuit Federal District Court, and appealed to and denied the writ of certiorari by the U.S. Supreme Court.
At the heart of this case is the issue of standing as articulated by Article 3 of the U.S. Constitution. Article 3 primarily limits judicial power of federal courts to actual cases or controversies. In this sense, it creates limitations regarding who is empowered to seek redress in federal courts. Under this doctrine, a plaintiff must meet 3 specific standards. First and foremost, the victim must have suffered an injury. That injury must be fairly traceable to the challenged conduct of the defendant. And finally, it must be likely to be redressed by a favorable judicial decision. In short, it requires that a concrete injury, even in the context of a statutory violation, can be proven. In other words, the principle of standing ensures that only those who have faced a wrong and therefore have a legal right to seek redress can pursue litigation. In the case of Zappos v. Stevens, the plaintiffs argued that they had standing because although they had not yet faced harm, the loss of their personal data at the hands of Zappos left them with a substantial risk of identity fraud and/or theft. Zappos refuted this claim and tried to dismiss the case by arguing that the factual scenario was that their database was breached, and however, no identity theft or fraud had occurred and therefore no harm was done to the plaintiffs. The 9th Circuit Court of Appeals stated that a plaintiff threatened with future injury does indeed have standing to sue if the threatened injury is impending, or if there's a substantial risk that the harm will occur based on the legal precedent of Krotner v. Starbucks. In this case, a thief stole a laptop with unencrypted names, addresses, and social security numbers of 97,000 Starbucks employees. With the data precedent and decisions set in this case, the Court of Appeals found that all 3 requirements of standing are set aside under Article 3 and that the plaintiffs did indeed have standing to seek redress against Zappos. The Supreme Court of the United States decision was to deny the hearing of this case, and this has important implications, especially for companies hoping to limit their liability in data breach cases. This ruling essentially transfers the burden of proof onto the company, as consumers no longer have to demonstrate actual injury, but can sue based on this idea of potential harm. This raises the priority of cybersecurity for businesses who are dealing with any sensitive customer information. As Natasha mentioned, e-commerce is increasingly popular, and businesses operating online will now have to be more concerned with their cybersecurity measures. The ruling on this case also is significant as it represents a circuit split on standing in data breach cases and class action lawsuits. In the 9th Circuit, the DC Circuit, and the 3rd, 6th, and 7th Circuits of the federal court system, cases have taken on a plaintiff-friendly view, whereas in the 1st, 2nd, 4th, and 8th Circuits, a defense-friendly view remains in place. In the absence of a SCOTUS opinion on the issue of standing in data breach cases such as this, the business's legal exposure after data breaches will depend, therefore, on the laws of the circuit where the claims are filed.
Following that analysis, we'd like to discuss our opinion as a group. As a group, we believe that while there may not actually be damages yet, the data was proven to be stolen, and the victims may have their identity stolen in the future. Therefore, we stand by the court's decision and agree that they should be compensated. Corporate responsibility for data is a good thing. It forces companies to place a priority on protecting its customers. We also believe that the district split is a bad thing. It places too much responsibility in the victim and doesn't give a consensus across the board of what will be the precedent. Finally, in any case, some precedent on behalf of the data breach victim is crucial. Whether the data has yet been used to steal someone's identity, the data is out there and the victim is still at risk. Since the court's decision, companies have been more protective of their consumers' data as they are liable for it, as we believe it should be. This concludes our presentation. Thank you for your time.